And welcome everybody to the 5th edition of the Deserve to Win podcast. As always, I'm your host, Eric J. Troutman, the czar of the TCPA, coming at you from the beautiful podcast studio. PJ, you're really making some improvement here on this fantastic shield painting. I love it. Yep. Thanks so much for being here. I'm very excited today. Our guest is the ultimate monster in the TCPA woods, the #1 scariest, most dangerous TCPA plaintiff's lawyer on the planet, according, of course, to my power rankings, Mike Greenwald of Greenwald, Davidson, Radbill. He's going to be joining us through the power of the Troutman firm a little bit later on, but of course, first, we'll start off by introducing the TCPA World crew. Queenie, why don't we start with you?
Hi folks, Queenie Pooja, General Counsel of Digital Thrive here.
The powerful General Counsel of Digital Thrive, great brand, thriving indeed, and good to have you. Over to you, the Wizard.
I'm the Wizard, founder and CEO of Direct Marketing Wizard. We're the fastest growing mail house in the West Coast at the moment.
And you're the man. He's also named. His name's actually PJ, which he sometimes go to.
That's
sometimes. No, your mail house is going fantastic. Of course, also operating a call center. So really, really great insights. Always very valuable. Thanks for being here. And then to my immediate left is, of course, the Baroness. Hi.
Hi guys. Brittany here, aka the Baroness, an associate at the Troutman firm.
Yeah, and Baroness tried to take a day off for her birthday the other day, and I just couldn't handle that. And it was really bad.
We survived.
Barely. You speak for yourself. You survived. I'm not sure I survived. And all the way over to the left is, of course, our newest addition, the Dame of the TCPA, Southern Belle. Introduce yourself.
I'm Tori Guidry. I'm the Dame of the TCPAWorld. I just started a few weeks ago, and happy to be here.
Yeah, associate at the Troutman firm as well. And, Dame, since you are brand new here, of course, I'm going to have to make you go first. So, do you have anything to talk about here today?
Yeah, the case Callier. It's coming out of Texas, serial plaintiff in these TCPA cases. Essentially sued 14 different defendants, 2 of which were sued personally and vicariously. The court ultimately found that one could be sued in such capacity and the other could not. The reasoning wasn't so clear, but I found, it interesting that even these people could be sued in a personal capacity of that nature.
14 defendants, wow.
Yeah.
Well, this is how Callier rolls. I mean, you know this guy,
yeah.
right?
Mm-hmm.
I mean, he's one of, and he's watching this podcast. Hi.
And he wants Troutman gear.
Yeah. Oh, yeah. He's actually probably wearing a hat right now while he watches this. No. So Callier is a decent fella, I suppose, but he brings a bunch of these cases. He brings them without an attorney, and he loves to, take advantage, frankly, of the law that says that you can sue people directly and personally in these TCPA cases. In his most recent attempt, he brought in 2 individuals, CEOs of their company, right, who are personally named. One of them, as you correctly pointed out, was let free because the allegations of the complaint were not sufficient to demonstrate vicarious personal liability, which is very weird. Like, you don't see that very often in these cases. And of course, though, the other plaintiff was shown, at least according to the allegations, to have been sufficiently vicariously personally liable. So in a weird way, it's actually a big win for Callier. Frankly, it's kind of a first-in-the-nation result that I'm aware of. And he does this. He brings in these little sneaky arguments, and he somehow seems to win them. I don't know if it's because people aren't taking him seriously enough or not. I don't know. But thank you so much, Dame, and thanks for being here. Welcome to the beautiful podcast. It's really fun to have you. Since we're over here looking this direction, Britt, why don't you go next?
Yeah. So like Callier, my case, this case was brought by a man named Nathan Barton in Washington. He's also a serial litigator.
He's probably watching too.
Hi, Barton.
Callier and Barton. So he sued this nonprofit organization, Serve All, Help All, in Washington for violations of the TCPA.
Hang on. How can you sue something called Serve All, Help All? I mean, come on.
That's terrible.
What do they do, by the way? Do you know?
I don't.
Oh, I'm sorry. I should have looked that up. All right, sorry, keep going. They serve all and they help all.
They serve all and help all.
Sounds like a good company.
Yeah.
Right. So Nathan Barton sued Serve All, Help All for allegedly unsolicited phone calls to his son's cell phone without his consent. So there's a bunch of motions going back and forth. Plaintiff brought forth a motion for summary judgment and a motion to strike. defendant, Serval Helpall, also brought a motion for summary judgment and motion to strike. But mainly I want to focus on is the motion for summary judgment piece that Serval Helpall brought. So the grounds that they brought the motion for summary judgment was stating that Nathan Barton didn't have Article 3 standing under the Constitution. He specifically attacked the first element of Article 3 standing, stating that Nathan Barton didn't suffer an injury in fact. Because he's a serial plaintiff, his entire scheme is to bring these TCPA lawsuits, and he buys calls and tries to invite phone calls, and that was his reasoning, that he didn't have Article 3 standing and didn't suffer an injury. Plaintiff, of course, argued against that and stated that he did not invite calls. He bought the phone for his son specifically for that purpose, and there was no consent. Ultimately, the court in Washington agreed with the plaintiff, and he lives to see another day.
He lives to see another day. So Barton, of course, very famous because Lead Point rolled over him with a steamroller, and I respect that. He had to pay $40,000. That was the order in another case because he was, in fact, setting up, in that case, his own harm by actually filling out forms with what he called his business phone number, right, which is literally a phone number that he was using to create TCPA cases. At that time, the court found there was this association between Barton and something called TCPA University, which was basically an online program that was teaching people how to, one could say generously, profit from the TCPA, and one could say, reading it from a different perspective, perhaps setting up your own TCPA lawsuits. Now, he distanced himself from the TCPA University ruling in the previous Lead Point case, or not ruling, from the TCPA University website in the previous ruling. He tried to do the same thing in his more recent filing. The court ultimately said, look, I don't care, right? If he's involved with TCPA University, that's something the jury will take into account. But for right now, we're going to find that he does have standing. The mere fact that he's brought a bunch of claims and that he might have a bunch of cell phones does not deprive him of standing if, in fact, he bought, as he claims, this phone for his kid. Now, the jury might ultimately be like, yeah, right, we don't believe him, we think he's a big fat liar. But for now, the court has to accept that allegation, that claim, that evidence at the summary judgment phase and let it get past the summary judgment phase. So we'll keep a really close eye on that case because I think it's a really interesting one. Thanks for breaking it down. Good job, by the way, Baroness. Let's throw it over to you, Queenie. What do you got?
So this one I like particularly because in-house compliance folks focus a lot on DNC policies and procedures, or at least they should be. This small little case, but it was Abood, I think is the appropriate Abood, the pronunciation. So in this one, it showed the importance of having policies and procedures, especially when you're trying to defeat class certification, right? One key piece for the defense side for evidence is showing that you follow your policies and procedures and what those policies and procedures are. So in Abood, the defendant was able to win on motion for summary judgment by showing that the agents, following their policies and procedures, have a pop-up screen that they share to the consumer to get verbal consent. And so the plaintiff tried to argue that this wasn't sufficient to dismiss a motion for summary judgment. However, the court disagreed, and so it's just a good reminder that something as small and as good as following your policies and procedures can get you out of a class action suit.
Yeah, that Abood ruling was fantastic because the plaintiff said, "Wait a second, Judge, you can't just take their word for it that they have the policy," and the judge was like, "Well, yes, I can." They presented evidence that was their policy. And the law has always been that evidence of common routine practice by a business is sufficient to carry the burden at the summary judgment phase. The plaintiff had the obligation to come forward.
Well, yeah, if they fail to introduce evidence stating otherwise, the defendant wins outright.
And that's exactly what happened. So, very good case. Thanks for breaking that down. PJ, what you got for us today, man? You want to talk about some mail center news, some call center news? Just want to say hi to all the beautiful people in TCPA world?
I would say hi to them, but I think most of them are litigators.
At this point, we actually have a pretty large following of plaintiffs bar.
We should have PJ break down Hunstein. You broke it down, but maybe since he's operating a call center and sending out maybe mail pieces.
So I'm not going to break down Hunting.
I don't think he does debt collection. You don't do debt collection.
I don't do debt collection.
No.
Okay.
I might send mail for one client that does, but more interestingly, I wanted to bring up something now that we're bringing that up. The state of Ohio and Wisconsin are looking at mail pieces and saying that you do need a telemarketing license, even though you're not making outbound calls.
That's ridiculous.
So this is something that has been going on for the last couple months, and it just keeps coming up.
Interesting.
This is news to me.
Yeah.
So many states do have telemarketing requirements. Usually you're talking about phone calls or text message outreach, usually, again, emanating from within the state to other consumers in the state. There's a dormant commerce clause issue if they're more expansive than that. So are we saying that here they're saying that the mail pieces come from anywhere in the country and we're going to be looking at it?
Anywhere, you don't have to call anyone, and if the consumer's calling you, they are saying that you may need a telemarketing license. So.
Well, this is interesting. If the Michigan or Wisconsin AGs are listening, and I'm sure that you are, don't call me about this because I don't really care. No, I'm kidding. I'd be very curious,
Ohio
actually.
and Wisconsin.
Ohio.
Yeah.
Ohio and Wisconsin. Ohio's been causing a lot of noise.
A lot of issues, yep.
Yeah, and not in a bad way. I mean, look, they're being aggressive. They're looking for more consumer protection. And it's funny because Ohio is a red state right now. And the Democrats get a lot of beef around consumer protection or being excessively pro-consumer and anti-business. But if you start looking around right now at the states that are being most aggressive in the marketing phase, or looking at licensing, looking at limiting, free enterprise, frankly, in the marketing space, it's the red states that are carrying the charge, which is actually very interesting if you think about that. Very good stuff, PJ. Anything else?
No, that's all I have.
You are the wizard, buddy, and I love having you. Real quick,
Thank you for having me.
TCPA World, I'm going to give you one quick little breakdown, additional news before we get to the interview, which is the Coldwell Banker Realogy class action. You folks, hopefully you're paying attention to this. If you are in the real estate game, you need to understand that real estate agents, their conduct can, in many instances, not in all instances, but in many instances, can be attributable now back to the brokerages. And I disagree with this rule. I don't think that rule is correct because largely you're not talking about vicarious liability in the true or classic sense of agency. But at least one court in California has found that Coldwell Banker's parent company, Realogy, can be held liable for the acts of all the independent Coldwell Banker agents all across the country who are sending text messages allegedly without consent. And this is a massive, certified class action, folks, that is scheduled to try in November. I mean, that's by the time you hear the sound of my voice, it's going to be about 2 months away, maybe less, right? 45 days away from a multi-billion-dollar class action trial. And there hasn't been a trial of a certified class action since Visalis, which, of course, you'll remember was that District of Oregon case from 3 years ago where Visalis got killed for $900 and something million. Jay's going to kill me for not having that number memorized. But so this will be the first mega trial in the TCPA world in nearly 3 years now. I'm dying to see how it goes. But if anyone listening to me is in the brokerage or real estate game, understand you right now, you have crosshairs on your back. Unfortunately, this is a very popular area for the plaintiff's bar to attack. Again, I do not think these cases are viable. That's my opinion. I think that these cases should not be certified. I think vicarious liability is almost always going, especially in the real estate context, where you've got different brokers in different places, different policies that are being applied, and many times different actual entities in different jurisdictions that all roll up into, for instance, a parent company. For all of those reasons, you're going to have highly individualized issues that should never permit certification. In addition to the fact that, of course, the substantive issues should always go against the plaintiffs who are trying to say that the companies are vicariously liable. But set all that aside, the truth is these cases are coming hot and heavy, fast and furious, and at least one, as I mentioned, has been certified and appears to be headed to a massive, massive trial.
Who do we got on that side? The plaintiff's side?
That's Avi Kaufman. I think he's brought in another firm. I don't want to name them because if I'm wrong, then I feel bad. But he's bringing him back up because obviously Avi's not going to try the case. He's going to have some other folks that are trying the case. So with that all out of the way, hopefully you enjoyed our little breakdown. I'm really excited to get to the guest. Mike Greenwald, the number one guy out there as far as I'm concerned, the scariest TCPA plaintiff's lawyer in the entire world, and I think his record really speaks to that. It's not just my subjective opinion. Yes, I think the guy's really smart, but I mean, he has had success after success after success. Very few defense lawyers can beat the guy. I'm happy to say that I'm one of the guys that has just crushed him in a case called Masters. If you ever have a case against Greenwald, just whisper Masters 3 times into the phone and he'll start crying. But in all seriousness, I'm really excited to bring you our interview through the power of the Troutman firm, Mike Greenwald. And now, through the power of the Troutman firm, I am extremely proud, a little bit nervous, to bring you an exclusive interview with number one on the power rankings for the top most dangerous TCPA lawyers on the planet, Mike Greenwald. Mike, welcome to the show, man.
Thanks, Eric. I might need you to do that introduction for me when I go to court from now on.
I'll be your hype man anywhere you go, because the truth is, you deserve it. There are very few lawyers in my career. In fact, I mean, without question, maybe only one hand worth of lawyers where when I'm in a deposition, when I'm in court, I'm thinking to myself, this guy might actually be better than me. And you are definitely on that list. So welcome to the show, man. I'm glad to have you here. If you will, just give everyone like a little introduction as you see yourself, and then we'll kind of talk about your origin story and talk about what you're up to these days.
Well, in terms of how I see myself, I think the more humbling way to look at it is how my teenage daughter sees me, which is nowhere near how you described me. I think she thinks I'm pretty much the stupidest person that ever walked the earth. So I will definitely show her this and see if that gets me any credibility. So thank you for that.
Yeah, teenage daughter, your dad's actually pretty bright, and take that from a guy who calls himself the Czar. Okay, so Mike, you're definitely most famous in TCPA world for just crushing victories in these wrong number cases. In fact, I'm not sure that you really pioneered the TCPA class action on wrong numbers, but you certainly perfected it. I mean, it's just no question. Nobody's got the track record that you have and the massive settlement dollars that go with that success. But what I want to start talking about, though, is everybody knows you as, the full-grown, alpha predator that is Mike Greenwald, right? The classic forest, the monster in the forest, monster in the woods. But how did you start off, man? Tell me about like your first couple of cases. You were telling me a little story before we got on. I thought was pretty good.
I started actually on the defense side. Some people may not know that, but out of law school, I wanted to come back to Florida, which is where I am, and the firms who were interviewing at law school were big defense firms. And not knowing really any lawyers or what I wanted to do, I went and started at a big firm in Fort Lauderdale, and only lasted there 2 years before I thought this probably isn't for me. Switched to the plaintiff side and worked at Robbins Geller, which is one of the biggest plaintiffs class action shops, doing some consumer cases, but mostly securities. Fast forward 6 years later, one of my best friends, Jamie, he and I started the firm, and I'd never heard of the TCPA at that point. We get a phone call, this is maybe 6 months into our new firm, from Aaron Radville, who is, of course, one of my partners now. And he says, hey, I've got this case. It's a robocall case. We've got some depositions coming up. Do you want to get involved? And being a brand new firm, not having a lot going on, we said, sure. And then it was from there. It was a wrong number case, just learning everything we could about the TCPA. There was really no established market at that point for settlement ranges for these cases. We didn't know what to expect. Ended up going to Chicago several times, taking depositions. It was a relatively small class, only 9,000 people. Ended up resolving for over $2 million. And we said, geez, we're really onto something here. So that case, actually, the mediation we went to, Jamie and I, my partner, we shared a room at the La Quinta going into the mediation, didn't know what we were getting into. Every expense was something you were stressing about, from mediator costs to deposition costs to everything else. And really, after that case and after we settled it and it was approved, we really started focusing more and more, not only on the TCPA in general, but more specifically on these wrong number cases. And there are a number of legal reasons for that. You get rid of arbitration, of course, if you're dealing with people who have no relationship with a company, and you're getting rid of consent in a lot of ways, which of course is the biggest defense to a TCPA claim. And so that's really, for the last 10 years, been our bread and butter.
So are you guys still staying at La Quintas these days? Or just the ones you own, right?
No offense to La Quinta, but we have not been staying at La Quintas for a while. I think that's fair to say.
Yeah, no, and I appreciate the origin story because, look, Mike, I just started my own firm. Look, expenses, they do matter. Now, I've been extremely fortunate, and I love all of you watching this because my clients have been remarkably loyal, and not only did all of my clients join me from Big Law, I actually picked up a ton of new clients since I've been on my own. So, I really don't want to say this out loud because I'm scared I'm going to jinx myself. But I've not had to have the La Quinta days. You know what I mean? The money was there, and it's been very profitable and very successful right from the start. But I love hearing your background because people look at you now and they think, oh my God, here's another one of these guys, and how many private jets does he have? How many boats does he own? But you came from humble beginnings and you worked your way up. So I respect that. So let's dive in a little bit let's start with the wrong number cases because that is what you're famous for. You guys, what's your record now in certification? Like 7-0 or something ridiculous?
So on opposed wrong number class certifications, we are 5-0. So we have actually not lost one yet. I know that's the biggest jinx, so that means that one is coming, of course. But now, and to be fair, we are obviously selective and strategic with which cases we're teeing up for opposed class cert motions, which ones we're seeing all the way through. So it's not as if we're picking from our worst that we're taking to the mat. But no, so far, knock on wood, we have had a great success record with them. And then in the settlement context, I couldn't tell you the exact number, but probably close to 20 wrong number TCPA class settlements at this point.
Yeah, I mean that is a fantastic number, and the most remarkable thing about that 5-0 figure, people listening to this might think 5-0, like who cares, right? Man, you get 5 straight certifications on a single theory. That means that lawyers, very good lawyers at big firms who've had a chance to see this argument, right? It's just like when you're preparing for, when you talk about football and, they're watching them on tape and they know what they're going to do, right? These defense lawyers know what's coming and they still can't stop them over and over and over again. I mean, that really says something about the level of skill that Mr. Greenwald is bringing here. And beyond that, I mean, the plaintiff's bar outside of Mike Greenwald is like 0-5, right? So if Mike's bringing the case, they're 5-0. If somebody else is bringing the case, it's not going as well. If you can share, are you guys only bringing these wrong number class actions in the TCPA space, or are you doing other kinds of TCPA cases as well?
Yeah, so Aaron Radbill and I primarily do TCPA, and then drill down to that. I would say, 80-85% of our TCPA cases are wrong number cases. And also, even on a finer point than that, they're pre-recorded voice cases, as opposed to, ATDS cases, and we can talk about why. But two of my other partners, Jamie Davidson and Jesse Johnson, they do some TCPA, but they're also doing other consumer protection and privacy cases. So we're in a few data breach cases. We have some products cases. We still do some Fair Debt Collection Practices Act and other sort of the alphabet soup of consumer protection. So as a firm generally, we're doing more than TCPA, but me and Aaron in particular are not exclusively, but pretty close to doing only TCPA.
So, Mike, on the TCPA, I mean, from the plaintiff's bar's perspective, I mean, is the TCPA, I always call it like the big golden goose, right? The big gold mine. Is that your view on it too, or are these other kinds of claims, are they equally as valuable? What do you think?
I mean, I wouldn't use that language. That sounds a little more pejorative than I would use on the plaintiff side. But listen, I mean, the TCPA is sort of a unique statute. It's uncapped, obviously, on damages. Whereas if you look at many of the other consumer protection statutes, they're capped, whether it's the FCRA or the FDCPA, capping something to 1% of a defendant's net worth turns those really into lodestar cases, which for people who don't practice is cases based on your hourly rate and the hours you have in a case. Whereas a TCPA case, you're looking at a common fund normally, and then fees determined as a percentage of the common fund. So certainly, I mean, whether it's the most lucrative statute, I think is probably open for debate, but at my firm, it is certainly the most lucrative statute. And also, I mean, if you look at the number of robocalls out there and you're dealing with $500 per violation, the numbers can be staggering, just with the rates of robocalls, the number of companies doing them. still making them without consent, still delivering pre-recorded messages. So it's not just the statute, of course, it's also the conduct of callers that's driving these cases too.
So Mike, bearing in mind that you're a guy, we talked about your roots, staying at La Quinta's, man. You're not staying at La Quinta's anymore. I mean, I think it's fair to say you've made millions and millions, frankly, of dollars pursuing these wrong number cases. I mean, do you ever get the sense that these are largely cases that just come, from mistakes that businesses are making? Do you ever think, maybe there shouldn't be such high penalties for people that are accidentally, essentially calling wrong numbers and getting caught? I mean, what's your view on that philosophically?
No, I don't agree. I mean, when you say not intentional, I mean, if your point is, are the big banks and finance companies purposefully trying to call the wrong person? No, they're not. But if you look at what I would call the reckless indifference by which they're doing it, I've never had a case against any of the bigger institutions where the number of phone numbers we learn in discovery that they're calling at wrong numbers aren't in the hundreds of thousands, if not millions. And so I think really what's happening here is it's easier, it's cheaper, it's more economical to call a number repeatedly, often with a pre-recorded message, and then ask the questions later. And so I don't view it as, oh, these are just a handful of accidents. These are hundreds of thousands of people who are getting called at the wrong number, who don't want these calls. And like I said, our focus is on cases with pre-recorded voice messages. The simplest way to avoid TCPA liability for defendants, and I hate saying it out loud, is don't use a pre-recorded voice. And that will get rid of a lot of these cases, and also the harassment that people feel. I have one now that I'm working on against a big financial institution that I won't name, where a person got a new cell phone number and got 150 pre-recorded calls for the previous subscriber, would answer the phone, and it was never, again, this is in 2021 that this happened, is never getting a human being on the other end, never even getting an IVR, press 1 to speak to a person, just a pre-record, this is such and such company, call us back, etc. With just putting it out there on the consumer to go take the time, call back, navigate a phone tree, wait on hold, to tell somebody to stop and then hope that works, is just, it's not how it's supposed to work. It's supposed to be right on the front end. And so if your point is, are they intentionally trying to harass this person in a sort of narrow sense? No, but in a larger sense, we know from discovery there are hundreds of thousands of people like this. And so there's just an indifference when you're making a million robocalls a day, that when you know that you're reaching a large number of people who are not your customers, in fact, you have a specific code that you use to denote that you're calling the wrong person, that at that point, no, I don't have too much sympathy for the callers, and I don't think Americans generally do either.
Yeah, it's a fair point that you're making, but I mean, what I see generally speaking is call centers are trying not to call wrong numbers. They're using data points and other kinds of processes to prevent the wrong numbers. But truthfully, calling wrong numbers is inevitable, right? Especially in an environment where you've got e-commerce, people are providing phone numbers on websites, getting phone calls in real time. The phone numbers might be fat-fingered, right? There's no way to know that. And of course, up until very recently, the reassigned number phenomenon was a huge driver of class litigation. And there was, as you know, there was absolutely no way that a business could know if a number has changed hands. But of course, that changed recently with the reassigned number database. What do you think about that database, Mike? Are you looking to reward people who are using that by bringing less lawsuits against them? Are you looking more to leverage it to punish people who aren't using it? What's your philosophy on the database?
Sure. I mean, I think it's a combination. I mean, one, obviously, this is a database that wasn't around previously. And honestly, from what I'm seeing in discovery, I'm really not seeing a lot of companies using it yet. Now, maybe we're suing the wrong people or the right people, however you want to look at it. But there's obviously, there's a safe harbor defense there. I don't know that it's been actively litigated, but there is a defense there. So I would hope that companies are going to start using it if they aren't already. But listen, the goal of all of this, right, is from your side and from my side, is to ultimately reduce the number of robocalls that Americans are getting. And if, I know there have been some issues with the database and the data not being complete, not going back far enough in time, that hopefully will get worked out sort of as time goes on. But yeah, if there are tools out there, whether it's the reassigned number database, whether it's one of the various third-party vendors that scores telephone numbers to see if they belong to a company's customers, companies should be using them. And if it won't completely eliminate liability because they're still choosing to use pre-recorded voice messages or an automatic dialer, you can certainly at least drive down the size of a class that could be an issue.
So if somebody's using the reassigned number database, and look, if you won't commit to it live on the air, I understand. But if someone's using that database, is that a less attractive target to you? Like, you do some discovery, you find out, like, hey, look, Mike, we're scrubbing all of our numbers on a weekly or on a monthly basis against the reassigned number database. Do you look at that like cold and pragmatic, like, okay, it just drives down the size of the class, but I'm still coming after you? Or do you say, you know what, this is a good actor, maybe I'll focus my fire somewhere else completely?
Yeah, I'd want to know more about the specifics of what the company was doing, and I just haven't encountered that yet. But listen, if you're looking every 30 days on that database, you're going to have a defense. And so we are certainly not in the business of prosecuting cases that we don't think we're going to win. And so if there is a good defense because of good compliance and a safeguard or a safe harbor that's been put into place by the FCC, yeah, I would think that is certainly a case that at minimum is going to drive a much lower value and may have us be less interested in bringing the case at all.
That's actually really good to know and really good to hear. Because, look, I'm not just going to talk about my clients. I know a lot of people in the TCPA world are struggling because on the one hand, the database, the merit of the database is obvious, right? It's got kinks. It's not complete. But obviously, knowing when a number changes hands is something that every call center that takes itself seriously should really be looking at. On the other hand, this thing is expensive, is what I'm hearing. Mm-hmm. It is not cheap. Not cheap to the point where people are looking at this and thinking, man, like, we really can't afford this. And so that is an interesting issue. Of course, your response will be, no, what you can't afford is a TCPA class action lawsuit. I should have let you say that. Go ahead.
Say, what else isn't cheap is defending a TCPA class action lawsuit.
That's right. And the fees of the czar aren't cheap either. So one last question though on the wrong number piece, and then we'll move on to something else. We won't talk too much about it because I think I know how to crack it. And you're gonna, you want to keep your secret sauce secret, and I respect that very much. But I'm just gonna ask it this way: are you surprised that the defense bar has not evolved to be more effective in opposing your strategy on certification in these wrong number cases?
Yes and no. I will say that in the cases that we have that have been certified, I think it's a mistake to just look at defense counsel and say, oh, these guys aren't good or they don't know what they're doing. I don't think that's the case. I think that, it's a few things. One, and I'm sure we can talk about it, we've lost plenty of things. Anyone who plays this game of litigation long enough is going to take some tough losses. So I think that's part of it. And I also think, irrespective of defense counsel, many of which are very good in these cases, is I think our theory is right. I think the courts have it right. I think if you read some of these decisions, they're lengthy decisions explaining why certification is appropriate when the class is properly defined, which is an important caveat. And, in 3 of our 5 cases, petitions were made under Rule 23F and the circuit courts denied the petition. So I don't think it's just, there's some novel theory that Mike and Aaron came up with that's untested or not properly tested. I think these cases are appropriately certified under Rule 23, again, in the right circumstances, with the right facts, with the right class definition. And you've seen experts on the defense side, good experts, well-regarded experts, well-regarded defense firms, who I think are doing a good job. It's just at the end of the day, when you're dealing with, what individualized issues really are we talking about here? We're talking about people who are getting pre-recorded voice calls who aren't whether it's a bank or a collector or whoever, who aren't their customers. It's really not overly complicated. in my view. I'm sure you would disagree. And so I think when it's properly explained and defined right, I really don't think there are a lot of unique defenses there.
Well, like I said, I promised I wouldn't put this on full display, but I mean, in my view, you guys have a hack. It's a hack, is what it is. You've hacked basically 40 years of procedural law. I know what you're doing. I respect it. I respect it very deeply. But it's a hack, is what it is. But we're going to move off of that, and I'm very impressed with what you guys have done. You've been very successful. I never take anything away from somebody who's come up with something, who's an innovator, right? And you and Aaron are innovators. You dream something up. It is, it's a remarkable thing. It's been remarkably successful. So, good for you. But don't try that on any of my clients. Okay, so let's talk. You talked about losses earlier. I built you up a bit. I'm gonna tear you down a little bit now, because you have had a couple of losses. The whole Bad Reyes scenario was really, really fun back in the predictive dialer days. But I'm actually really interested in the Johnson case, because, from a certain light, and, I'm a little bit prone to hyperbole on occasion, but in a certain light, I mean, the Johnson loss is one of the biggest losses in the history of class certification from a plaintiff standpoint, in the sense that you actually managed to lose incentive awards for an entire state, an entire circuit, which is very impressive, Mike. But I'll let you tee this up and explain it through your lens, and then maybe I'll provide a little color too.
Yeah, so I like your hyperbole a lot better when it's positive than when it's negative. Just put that out there. Yeah, wow. I feel like this case has taken years off my life, but it's a TCPA class settlement down in the Southern District of Florida that I think goes back to 2017, and here we are in 2022. A routine class deal, non-reversionary common fund. All cash, so none of the red flags in terms of any coupons or debt relief or any reversion to the defendant, sort of none of the hallmarks of a bad settlement. A good deal. Claimants were getting, I think, roughly $80, and the plaintiff was awarded in the district court a $6,000 incentive award. Fast forward however many years later, and the 11th Circuit on a split panel, so a 2-1 panel decision, said not only was the incentive award to our class representative improper, but incentive awards generally are improper. There was then we asked, with some help from seasoned appellate attorneys, for the court to revisit it en banc. It took almost 2 years, and we just got that opinion down, which you're referring to. And we did pick up 4 dissents, which is helpful, but obviously isn't going to carry the day. So that's where we are. It's a circuit split that is the 11th Circuit on its own, and then everyone else on the other side. And it really upends, 40 or 50 years of established rule that incentive awards in the right circumstances, again, it can't be, an outrageous number relative to what the class is getting, but something to really award a person who puts their name on a pleading, puts themselves out there, is subject to discovery, to scrutiny, gives them a little something for their efforts and everything they've put into a case and what they've accomplished for absent class members. So that's where we're at in that case, and we're gonna file a cert petition and see if we can get the Supreme Court to change their mind.
Now, is that breaking news that you're going to be filing that cert petition?
It
you
is.
Just announced that.
We have not said that publicly before, so there you go.
Well, there you go. Well, thank you very much. So there you go. Breaking news, folks, are going to be appealing. But for those of you that are kind of wondering, wait, what is an incentive award? What are these guys talking about? So when you bring a class action, the individual who brings a class action is, if they are successful in bringing forth a settlement for the class, they are, in most jurisdictions, entitled to something called an incentive award, which is a payment, $5,000, $10,000. I've seen it up to $20,000 that they get, with the concept being, look, you brought benefit to a whole group of people, and you deserve more than everybody else that just sat at home and got a postcard in the mail and sent in a claim, right? They get their $50 or $100 or whatever it is, but you, the person that went through a deposition, that got grilled by Troutman for 7 hours, that had to fly around and do all these things, attend to hearings, you get more money. And I'm going to tell you something, Mike. I agree with that. Right? I mean, I in the Johnson decision, the appellate court, you know this better than I do, the 11th Circuit split panel went back to 2 decisions from the Supreme Court from the 1800s, which have absolutely nothing to do with Rule 23 or with anything that has to do with the modern class action. And in my opinion, were very narrow holdings that basically just say, do you get paid essentially a wage for bringing litigation, right? And the answer that the Supreme Court gave at that time was, no, you don't get to get paid, right, an hourly wage while you're traveling from Philadelphia to Chicago on a train in order to attend a deposition. You don't get paid for that time expressly, which is fine. I mean, that's like a very narrow, specific holding, again, predating anything under Rule 23. It has absolutely no bearing at all on the current modern FRCP, the class action process, or frankly, the good sense, that lies underneath. And don't get me wrong, I hate consumer class actions. I think the vast majority of them are garbage. But where there is a valid one, a true one, and there are, right? There are certainly cases where consumers are actually injured. Again, never under the TCPA, but there are, right? And people bring these class actions, and they ought to be incentivized. That's my personal view. I think that's the view of virtually every judge that is out there, whether you're conservative or liberal. You think, hey, there are cases where the class action vehicle is the appropriate vehicle, and there should be an incentive there. So it's going to be one of the few places that you and I actually completely agree on something. I think that the Johnson decision is flat wrong. And you're never going to see me take a different position in a brief, because I won't. I'm an intellectually honest guy, and that's just not the right holding. So if you want to cite the Czar, feel free.
I appreciate. Actually, I think you were cited in our petition for en banc review. I'm pretty sure about that, actually.
Well, unfortunately, it didn't get done. I was cited to the Supreme Court too recently as part of a cert petition. I don't know if you know that. So maybe you want to include me on your new cert petition while we're talking about it.
Cert petition granted, because that's how.
I think it was.
There you have it. That's yeah. I mean, one other point I would put on this, and I won't get into the weeds of the legal issue, is what I think sometimes, whether it's judges or practitioners, people who are lawyers who, you're in depositions all the time, you're in mediation all the time, you're responding to discovery for your clients all the time. And for us, it's no big deal, right? It's what you do every day. If you have a named plaintiff, and we rarely have repeat plaintiffs that we use or that bring cases and retain us, it's a lot for a person to put their name out there. When you Google, some person's name, this lawsuit comes up. And when you get interrogatories or requests for production, and you're trying to answer them as best you can, and you have to prepare for a deposition and have somebody asking you questions, and they're using legal terms and you're not sure what's going on, it's a lot for somebody to do that, to put themselves out there. And they do that, a lot of times altruistically. They're trying to get a benefit for something they believe in. Now, again, we can disagree on the merits of certain cases, but the plaintiffs believe in them. I believe in them. And, for what is really in the scheme of how much a settlement is, a settlement well over $1 million, to have somebody get $6,000 as just a token for your name will be forever linked with this. You had to respond to discovery. You had to do all these things, and you got a benefit for thousands of people who otherwise would not have stood up for themselves. I think it's a really important part of the system and making the system function right. So I'm hopeful that we'll get this opinion reversed.
Yeah, it was great until you ruined it, Mike. Way to go. No, I'm just kidding. So let's pivot. Although we're talking about en banc appeals to the 11th Circuit, and of course that brings me to talk about Hunstein. And again, I'll set the table real quick. So for those of you that don't know, in Hunstein, this was a case under the FDCPA, not the TCPA, in which it was held that providing data to a vendor who was going to send out what's called a dunning letter, but ultimately any vendor that's going to send out communications to the debtor, that the sterile production of information about a debt to a vendor to send out a mailing is a violation of the FDCPA's requirement that you not share information about a debt with a third party, which of course stems from the ancient rules against public disclosure of non-public fact. The Hunstein court said that was a violation, that you could bring a class action, and essentially every single person that had ever used a vendor for debt collection purposes was violating the FDCPA. It really set people just scrambling. It was a terrible ruling, in my opinion. It was terrible. And it was just overturned on standing grounds, though, Article 3 standing grounds, looking primarily at the Ramirez Supreme Court case. Very curious for your take on this, Mike.
Well, so as much as we agreed on the incentive award issue, I totally disagree with your take here.
Back to normalcy.
Yeah, exactly. Back to normalcy. So this opinion really bothered me. So I'm very big on access to courts. I think it's really important that people who are aggrieved, who have a case, have a venue in which they can complain. And I think where standing has gone, it's confusing, it's impossible to apply, and I don't think it's tethered to anything that's actually in the Constitution. So let's just talk about, where we are in the 11th Circuit. So in the 11th Circuit, one text message, right, we'll take it back to the TCPA, one text message is not enough for standing. In the 9th Circuit, it is. Right. Okay. So one text message, not enough. More than one phone call in the 11th Circuit, that is enough. And then one phone call, the 11th Circuit just remanded a class settlement to have the district court figure out whether one call is enough.
Great.
So, what is that? I mean, what kind of framework is that anyone can get any kind of sense of whether you can be in federal court or whether you have to be in state court? To me, it's sort of lunacy at this point. So if we say one text message is not enough, is two text messages, is 3, is 10, and this sort of line drawing and artificial sort of hair splitting that we're doing here, I mean, how is that tethered to anything in the Constitution? But that's that's somewhat of a separate issue. Like Ramirez and Spokio say what they say, so I understand the paradigm that we're traveling under. But even in that paradigm on Hunstein, I think Judge Newsom, who ironically it was wrote the panel decision in the incentive award case. So I disagree with him there, but I think his dissent in Hunstein really hits the nail on the head, which is, on the one hand, we're saying, it's not common law that's the source of this cause of action. It's the FDCPA. So the FDCPA, which expressly was enacted, among other things, to protect consumers' privacy, has a provision, a standalone provision that says, hey, debt collectors, you can't disclose personal information about people without consent. So again, if you have consent, you can do it. But without consent, you can't disclose their information except to the following, whatever it is, 6 exceptions. And so the protection of people's personal information is something that Congress said, hey, debt collectors, don't do this. And for the standard to be, yeah, I know that Congress said you can't do it, and I know that part of the reason of the FDCPA is to protect privacy, but we're going to compare that to a common law tort, one of the subsections of invasion of privacy that weren't even around when the Constitution was written, but came up in common law in the 1800s, and then compare element by element, even though you're not bringing a common law claim. To me, it just makes no sense at all.
All right, but substantively, do you think that Congress intended to prevent debt collectors from sharing information with people that are sending out letters?
Well, it's not just what they're doing. I think if it was as simple as that, because we brought some Hunstein cases, and I think we might have had the only, and maybe it'll be a relic by the time it's all said and done, the only Hunstein class settlement that went through.
Yeah, don't those guys feel like suckers, by the way?
You know what, though? I don't think that's necessarily true, because...
It's not true. It's not true at all, because at the time that the settlement went through, it was a good settlement. But now, looking back on it...
Well, and also don't forget, Article 3 standing for your audience just means you can't bring the claim in federal court. It doesn't mean you can't bring the claim anywhere. And so I'll get back to your question in a second, but some states are going to adopt or have adopted or already have an Article 3-like component in there, whether it's by state law or in their own state constitutions, and others don't and won't. And so I think what you're going to see happen is you're going to have federal statutes that are adjudicated in various state courts with probably varying answers. So you may have one state Supreme Court that issues a merits decision on a Hunstein claim that ultimately conflicts with a merits decision on a Hunstein claim that another state issues. And none of this seems to make any sense to me. But going back to the original question, they're not just printing letters. If it was simply, I'm sending a data file, it's encrypted, the letter's printed, everything's deleted, and that's the end of it, I'd be more inclined to agree with you. But we took depositions in some of these cases, and the big letter vendors, the big names, they aren't just printing letters. They're taking data files and they're storing them. They're storing the data for years, up to 7 years. They're taking copies of the letters in PDF format and they're keeping them. So again,
but what's wrong with that, Mike? I mean, they're maintaining a record of the communications that they sent. You know, I'm not trying to push back on you too hard here, but when you think about the context of debt collection, and this is it strikes to the heart of what the standing analysis was, right? The essence of the rule is to prevent public disclosures. It's to prevent debt collectors from doing heinous things like embarrassing debtors by telling their ex-boyfriends and girlfriends and coworkers and friends and family and nephews and nieces, hey, they owe me $500 and won't pay me back, right? That's what they're trying to prevent, not some sterile storage of a letter that was sent from 5 years ago that the debt collecting mail shop is maintaining for their own records. I mean, do you agree with that, or do you think I'm off base?
I don't agree with you. I mean, that's not what the statute says. So I think you're conflating what the statute says with what the elements of a common law, invasion of privacy tort are. And what the statute says is don't communicate with third parties or regarding somebody's debt unless it's one of these enumerated exceptions, of which a letter vendor isn't. But yeah, I think in today's world, I think having control over the privacy of your information, and I don't want my, if I owed a debt, how much that debt is. Maybe it's a medical debt, like in the Hunstein case, that somebody sought medical treatment, where they sought it. That a debt collector without consent and can just send that to a vendor and have them keep your information for years, or I don't have access to it. I don't know as a consumer what your data security protocols are. I don't have any control over what happens at that point. I think these things are important, and it's not as simple as, well, somebody's just printing a letter and that's the end of it. They're keeping private data about you that Congress said they're not entitled to have. And so, yeah, to say that somebody doesn't have access to a federal court over that, I think is incorrect. Now, we'll ultimately see. I mean, obviously, the 11th Circuit has spoken. There were 4 dissents. I know my firm we're fully briefed on appeals in the 3rd and the 7th Circuit now. Jamie Davidson and Jesse Johnson, 2 of my partners, are certainly far bigger experts on Spokio and Ramirez than I am, and they're arguing these cases in the coming months. So we'll see what happens in terms of a circuit split, and even if it's just the Hunstein claim on its own, I think it's really a broader question of access to courts and how this seems to be sliding, I fear, toward people not being able to get redress in cases where it's hard to show harm. You don't know, like in a data breach, you don't know, or in a biometric privacy case, once that information is gone and you've lost control over it and some third party has it, it's hard to know what's going to happen with that, or if you have adverse consequences, how you tie it back to that breach or that disclosure. And that's why, and again, it's separate from standing, that's why these statutes have statutory damages to begin with. That's why it's $500 per violation of the TCPA, up to $1,000 per violation in the FTCPA, because these things are hard to quantify, but that doesn't mean they don't cause harm or can't cause harm.
Yeah, I mean, the whole thing is very interesting to me. I mean, you keep going back to, originally, where is this in the Constitution? I guess for the viewers, it comes back to Article 3, right? Literally, in the Constitution, it says there has to be a case or controversy in order for the federal district courts to have jurisdiction. That is Article 3 of the Constitution. And that's where this whole line of cases comes from. What is a case or controversy? I mean, if you look at it, from one lens, well, anytime 2 people disagree, it's a case, right? It's a controversy. But if you look at it through the lens of I guess like 100 years now of legal jurisprudence that courts have come up with, is actually a three-pronged test, and one of those, of course, is concrete harm. And what we've been talking about this whole time is how do you apply the concrete harm test in the setting of FDCPA or in the setting of TCPA. But I don't disagree that, I can't disagree. There is a clear trend in the courts toward closing off the doors, narrowing what a case or controversy is for Article 3 purposes, narrowing what a concrete harm is. In the TCPA context, I disagree with you that it is, is it 1 call or 2 call or 5 call or 10 call? It's a qualitative, right, not a quantitative analysis. And to me, the essence of Spokio is and always will be that the TCPA is dead from a class perspective, because assessing qualitative harm from something that is essentially a subjective nuisance is impossible on a class-wide basis. It is always going to turn on the individual mindset of each class member. I know you disagree with that. You can respond if you'd like. I know you don't have to, because I know you disagree, but you might remember I'm famous for the day Spokio was decided. The day I wrote a blog and I said, this is the end of the TCPA's class action, because there can never be demonstrable class-wide concrete harm from something that only causes nuisance or subjective harm, not actual objective harm. You disagree.
I disagree. I think since Spokio has been decided, obviously, we've still done pretty well with TCPA class actions.
That's true. That's a fact.
They're not dead. But I think what you're saying, I don't want to get too in the weeds, but I think when you start saying that violations of the law, you have to apply sort of a value judgment as to what harm there is now you're already looking at it in the wrong way. The point being, Congress said, don't make pre-recorded voice calls to people's cell phones without permission, period.
Congress can't create a harm. That Spokio is dead on there.
No, they can elevate a claim that was previously unavailable under common law. Spokio says that, and so does Ramirez. But then you have, if you look at Gadalahack and the Seventh Circuit, which now Justice Barrett wrote, you're looking at it's an intrusion upon seclusion, however you want to, make the analogy. But it isn't subjective. Is this something, and again, I don't agree with the standard, so I'm not conceding it's the right standard, but can you say that this is sort of close in kind, if not degree, to a common law tort like intrusion upon seclusion? So we're really getting in the weeds here, but let me just say, I guess I disagree with your take that Article 3 standing ends TCPA class actions. But even if it did, all that's going to happen, which is what already is happening, and which I think defense counsel are ultimately going to regret if they don't already, is the transition of these cases to state courts, which are much more unpredictable and varying, there's 50 of them, than the federal system.
All right, man, we're out of time, so I'm going to ask you the question I ask everybody at the end of these interviews, which is, look, first of all, you've been a great guest, Mike. I hold you in the highest regard. I could do this for 8 hours, you know that. But I'm going to ask you, for the people that listen to this podcast, right, call centers, folks that do direct-to-consumer marketing, folks that are in the servicing space, debt collection space, what advice can you give them? Advice is the wrong word in this context. You're a lawyer. You're not giving them legal advice. But, in answer to the question of what can they do to best position themselves to deserve to win, which is, of course, the name of the podcast, Deserve to Win. What can they do today to deserve to win and put away the risk of TCPA class actions from guys like you?
It's a complicated question. I think there are simpler ways to comply with the statute, namely limiting your use of pre-recorded voice messages, using third-party vendors out there to try to make sure you're calling the right number. And then on the marketing space, one thing that I think, and I'd actually be curious on your guys' take on this, is trying to use two-factor authentication when a lead comes in would probably get rid of an enormous percentage of both false leads and leads that, where there's some error in terms of somebody typing in the number. I can't go into a bank account, or in fact, I was ordering lunch the other day and it made me do a two-factor where it texted me to say, hey, is this your order? I don't know that any marketing sites are doing that. And that would seem to be a very simple way to make sure people are calling the right number. and to make sure that leads are legitimate.
Now, I respect that answer, but is that a trap, Mike? Because will you not turn around then and sue these companies and say everybody that did not respond positively to the MFA effort must have been a wrong number, so give me a record of everybody that you sent the multi-factor to that didn't say, yes, I want that. Isn't that the play? I know what you're doing, Mike.
There are no traps here. No traps here. Just good, honest advice.
All right, Mike. Well, you're fantastic. Thank you so much for being with us. Round of applause for this guy. Great. Good job, Mike. Wow, I gotta tell you, folks, that guy is amazing. I love Greenwald. He's so bright. I could literally sit and talk to the guy about esoteric little legal issues for 10 hours. You don't want to hear that, so we cut it a little bit short. But that guy is brilliant. I'm very curious. Let's go around everyone's thoughts. We'll start with you, Queenie, if that's okay. What did you think?
Great guy. By that I mean he's a great lawyer. I like that Mike had mentioned that he doesn't use repeat plaintiffs, right?
You caught that.
I caught that, right? And it's true to what he says, right? He actually brings legitimate claims often. So when you do get a demand from him, typically I'll take it really seriously. And then additionally, the pre-recorded piece, right? He couldn't have stressed that enough, right? And it's something that I know Eric and I, we preach, get away from pre-recorded calls, right? It's the death. As you heard Eric and Mike talk about, pre-recorded calls always fall within the purview of the TCPA. You always need consent, so it doesn't matter if you're using ATDS or not, so just something to keep in mind. And you heard it right from Mike's mouth, right? That's what he's going after these days.
Yeah, great thoughts there.
And one additional piece, the reassigned database. I'm glad you addressed that because I was going to bring it up if you didn't. Yeah, it's interesting to see that he backed away a little bit, right? He didn't address directly whether he's backing away from those cases, but I do think they have an impact, right, in a positive way, similar to how the DNC scrubs do, the litigator scrub, all these compliance solution vendors, I think, are going to help, and they're going to push these plaintiff attorneys away.
Yeah, I mean, I'm a huge believer in the R&D, and I was really hoping that he would say live, take a stand, take a position and say, look, if you're using it, I'm not going to come after you. That would have been very powerful.
I almost think he doesn't want folks to use it.
Well, I mean, that's the truth. Of course he doesn't. Of course he doesn't. He's sitting back hoping to God that nobody ever uses the reassigned number database, because not only does that continue to allow these cases to come, it gives him an argument to say that they were willfully violating the statute.
Yeah, I will note though, it's not advertised enough as much as it should be. A lot of folks aren't aware of it. They don't understand what the reassigned database actually does. So for folks who aren't, familiar with it, look it up.
Maybe we'll have Beth on the podcast.
I was just thinking that, so we should have Beth on the podcast.
Brilliant. PJ, what'd you think, man?
I liked him. Normally, I don't like the other side that much.
Well, you liked Adrian last time, too.
I did like Adrian.
You're getting to be a softie, man.
I don't say it. I might go to the other side.
Whoa!
No, I'm kidding. No, he brought up very valid points. Like, very obvious. You want to stay out of trouble? Stay away from anything pre-recorded. Like he made that a fact, just like Pooja said. But one thing that was very interesting on the reassigned number part was it's not one accidental call, like you said. He wants there to be, in discovery, hundreds of thousands. He's looking for those bad robo-dialers that are just dialing the phone book. He's looking for the bad people. So I think he's not a bad guy for being on the other side.
Okay, I'm going to have a rebuttal to that. But we'll let the other folks have a chat, too. Tori, your first time on the show, The Dame. I hope you had a really nice time on your first podcast. And it's your first interview that you got to watch. What did you think? I mean, you can critique me. You can be like Troutman. Czar, I thought you could have done a better job. But, I mean, did you have thoughts on what you heard?
Well, I'd rather not critique you. But I thought it was really interesting and noble that he does go after the bad actors instead of, only bringing these viable claims. That gives you a lot of respect, I'm sure, in the industry, and especially with the defense bar. I mean, if you're getting something from him, it's serious and it's going to have some kind of, viability to it.
Well, the guy certainly knows what he's doing, that's for sure. Anything else?
That's all from me.
All right, fair enough. Welcome to the show again, Dame. And Britt, you get to go last. What'd you think?
Yay. I thought the first piece that was interesting was that he started off as a defense attorney and then eventually switched over. So I thought that was interesting because I'm starting to learn more people that are on the plaintiff side actually started off on the defense. And then the second piece I thought was interesting was the two-factor authentication. I was like, that's interesting. I've never heard of something like that, but it'd be really interesting to implement that and see that work out in, actual time.
Well, I appreciate all of your thoughts. I'm going to tell you, I disagree. I don't think he's noble. I don't think he's a good guy.
Okay.
I respect Mike Greenwald. In fact, in many ways, Mike Greenwald is probably the nemesis of the czar. He is, I'm not messing around. Of all the plaintiffs' lawyers I've gone against, he's probably the smartest I've ever gone against in my career. I remember a series of depositions. I was dealing with him one time in Portland, Oregon, and he got through in about an hour of questioning of my witness. I went back with the corporate rep, and I was just analyzing this, and I was just thinking, oh my God, he just destroyed us. And I'd never had that experience before in my life. The guy was so well equipped and so intelligent. That being said, he's using his powers for evil. And I love you, Mike. I love you. But you are so smart, and there's so many better things you could be doing. These wrong number class actions, these are always gotcha cases. They're always gotcha cases. My clients, everybody out there that's trying to make outbound calls to consumers, they are not intentionally calling wrong numbers. And they are actually actively trying not to call wrong numbers. The problem is that when you get a wrong number, you don't know it's a wrong number until someone tells you it's a wrong number. And these class actions are not built on suing people who know it's a wrong number, i.e. focused only on people who said, don't call me, it's a wrong number, and then got calls. If that's what these cases were, sure, good. Now you're doing God's work. But that's not what these cases are. What these cases are is a gotcha. You find out it was a wrong number, and they sue you not for the calls that came after, but for the calls that came before. Because all of those calls were technical violations of the statute, even though you didn't know you were violating the statute. And now there's the reassigned number database, right? Now defendants have a fighting chance. Good. But before that database existed, there was no fighting chance. You were dead. If you were making outbound calls to try to contact consumers, phone numbers were changing hands at the rate of 10% per year. And there was nothing you could do about it. Nothing. And there was guys like Greenwald, again, respect him. Highly intelligent man. Highly intelligent. But they're sitting there waiting for these big companies to do what they were inevitably going to do because they had no choice, which was violate the law. All they were trying to do was contact their customer using the best information that was on the market that was available, using an effective means of communication, and they're being sued for billions of dollars. That's not right. It's just flat not right. And that's why most of my career was spent defending uniquely wrong number class actions. And those class actions, folks, I've been extremely effective defending, not just because I believe that that's the right thing, but because, although Mike has an incredibly clever hack to get around the rules of Rule 23, really these cases should not be certified. And I look forward to the next time that I get to go to battle against Mike. He really is just a tremendously intelligent person. But if you folks are facing a TCPA class action regarding wrong number calls, you have to understand these things are often certified, even though they should not be. You're talking about billions of dollars in exposure, very, very, very high exposure in these cases. Do not take them lightly, especially if Greenwald is on the other side of these things. The guy is a monster. All right, that is it for episode 5 of Deserve to Win. We really hope that you enjoyed it. I loved hearing from everybody. This is a great crew. I love having the Dame here. It's great to have you. I hope you're having as much fun as we are every week because we love it. Give us a like, give us a follow, tell your friends. We'll see you next time. Bye, everybody.